Hey, old folks. I keep forgetting to close this door. Good morning. We are returning to the Dan Markel murder. Dan Markel was killed because he wanted to be a good dad. In 2014, the marriage between Dan and his then wife, whose name keeps escaping me, was ups and downs, and then Jesus Christ, let's be professionals. Let's be professionals. Jeez. Wendy. Let's be professionals. Yeah. And then at one point, Wendy Adelson took their two sons while Dan was away on a conference and cleaned out the house, emptied more or less their accounts, took the boys, and disappeared. So apparently the marriage wasn't as solid as Dan might have thought. What ensued was a really, really dirty divorce. Why is this going out? Where Dan, he got his visitations rights. I mean, because you just can't take the kids and disappear. There are no evidence of foul play whatsoever. It was just that Wendy Adelson wanted it all. The money, the kids, everything. Now, both Dan and Wendy Adelson are lawyers. Well, Dan was a lawyer. Not only was he a lawyer, he was a professor at a Florida university, a law professor. So you can imagine once they got into divorce, I mean, I've seen this pile of papers from that divorce. But it seemed like Dan was winning the custody battle. And then he got murdered. So far, there have been a few trials. The two people hired to kill him, life in prison. The middleman, or middlewoman in this case, hung jury first time, convicted the second time. Then the person who paid for it, Charlie Adelson, Wendy's brother and Donna's son, was convicted last year. And now it is time for the matriarch of the Adelson clan, Donna Adelson. She was charged late last year. They had to catch her boarding a plane to Vietnam with one-way tickets. Vietnam has no extradition agreement. So now it is her turn. Now, this case has been going on for 9 years. And today, we are going to watch. It is live right now. We are just, maybe 45 minutes behind. It is a motion to dismiss the charges because of the time it has taken the state to bring these charges. And I listened to a bit of it in the car, and reluctantly, I have to say, her lawyer makes a good argument. Now, I haven't listened to it for a good half hour. I have no idea if there's been any rulings or anything, so we will just start from the beginning. Now, the reason why I say I reluctantly say her lawyer has a good case is because Donna Adelson is a despicable person. In the communications that the cops retrieved, in order to spite Dan Markel, Donna Adelson suggested to her daughter that they dress up the kids in Hitler Jugend uniforms. What makes this especially despicable is both Markels and the Adelson are Jewish. Dan's grandparents survived the Holocaust. Yeah. So when I say I reluctantly say that her lawyer, Donna's lawyer, makes good arguments, I really mean it. Because Jesus Christ, I want to see her in prison. But you still have to get there by proper methods. So, folks, let's get to it, so you also hear these arguments. Let's go. I think this. All right, I will play it in 1.25.
Clear on this. Have a good day.
Thank you.
All right, let's turn to the other matter scheduled for this morning. Case number 2023 CF 3226, State versus Donna Adelson. All counsel have record will make their appearances.
Really bad.
Georgia Kappelman for the state, Your Honor.
From the judge microphone. I can't do anything about it. Hello, everybody. Dali is here, Dream is here.
Before I get off, Len and McNair, Ms. Dugan, I neglected to ask you if you have anything to add on behalf of the state. Bailiffs, if you please, can get back to defense counsel. Do you have anything to add, Ms. Dugan? Very well. We'll continue with Ms. Adelson at this time.
Oh, and her
Let me
lawyer
go through all the
represents
motions that
Charlie.
we are. Let me turn on the Zoom as well before we get rolling.
I know, Dali. I got notified about it. It's not. Yeah, Sarah Boone has a lawyer now apparently, and but it's not on the court docket yet, I think.
Expecting to join via Zoom this morning.
I was thinking at least 3, Your Honor. You see
Oh, I
Markel
see.
and Shelley Markel.
That prosecutor did an
I see Zoom
amazing
entries
job
for Ruth
at the last
Markel,
trial.
Phil Markel, and I believe some other interested parties or onlookers. All right. Beyond that, I will keep an eye on anyone who is attempting to enter. I do see one now for Shelley Markel as well.
Thank you, Judge.
For everyone who will be listening via Zoom this morning, you are not to interfere with the proceeding. However, you may listen to the argument of the attorneys and also the court proceedings as they unfold. Again, please do not interfere in any way with the proceedings. Mr. Rauschenbaum, does the defense have anyone that you anticipate joining via Zoom this morning?
No, Your Honor.
Very well. To go through the motions that we're going to hear today, we're going to address the state's motion in limine, the defendant's motion to use a jury questionnaire, the defendant's motion to suppress wiretap interceptions, the defendant's motion to dismiss the indictment for pre-indictment delay or to exclude evidence, the motion to hold the trial in courtroom 3B, and also the defendant's motion in limine. I believe the defense has also filed an additional motion in limine Mr. Morris, if you can explain as to that as well.
Judge, we didn't first anticipate the court taking that issue up.
He will start to use the microphone eventually.
But the motion was filed based on the receipt after the deadline, the discovery deadline, if you will, for in Mr. Corbett's presentation, which is 300 and something odd pages. Mr. Ashbaum, there was some back and forth in terms of when we would get it and that sort of thing. We needed it before Sergeant Corbett's deposition, which was taken with.
Talking to a microphone.
Yes, sir.
It's a standing order of the day. Everyone who speaks, speaking to a microphone.
His deposition, Sergeant Corbett's deposition, was taken in the midst of last week. And so the motion was filed immediately on the heels of that once we learned the information that was associated with his testimony and presentation.
Very well. As to that motion, I've not had an adequate opportunity to review it. I assume the state needs some time to prepare this as well.
I'm happy for it to be heard whenever it's convenient for the court, Judge.
So we can stay on our existing timeline of meeting the jury selection on the 17th. For now, let's tentatively schedule this for September 6th. Please consult with Lynn as to a particular time and courtroom. If I'm going to need additional time before we get to the 6th, I'll let you all know. Right? And also, the other motion that we will hear today is the defendant's motion to preclude travel as consciousness of guilt.
Judge, for the motion that was filed this week by the defense, I did go ahead and put that draft of the presentation that they received on flash drive for you, 329 page one. I have sent one or two things since then, I believe, to the defense, and I guess they'll just let us know if they have an issue with that.
Right, thank you. One other matter that I wanted to address as well before we get into the argument of the motions. Mrs. Adelson, previously I have addressed with you the fact that you are waiving any conflicts as it would relate to the representation of Mr. Rauschbaum. Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand. Do you swear or affirm the testimony you're going to give will be the truth?
Yes.
You can lower your hand. Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case, or a similar case, in this matter?
Yes.
Do you understand that he has a duty to hold in confidence certain aspects of that representation?
I understand.
Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial?
Yes.
As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way?
Yes.
Have you had an ability to consult with other counsel as to whether you wish to have conflict-free counsel?
I'm aware of it. Yes.
And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this?
Yes.
Thank you. You may be seated. And again, so it's clear why I'm doing this, ma'am, at this stage, as we move closer to trial, things are going to occur rapidly, including rulings on the motions that you filed, rulings on the state's motion, how this is going to affect the evidence, and how this will ultimately affect your trial. At any point, if you decide that you are no longer willing to waive this conflict concerning the representation, that is something that I'm going to need to address. Do you understand this?
I do.
If defense counsel as well becomes aware before the next hearing that the conflict is no longer waived, please bring this to the court's attention.
Yes, Your Honor.
All right. Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay. Mr. Morris, Mr. Rauschbaum, whoever is arguing this on behalf of the state, I'll allow you to proceed at this time.
Judge, may I first lecture?
You may.
I got it right, lecture.
A+ for use of grammar. Go ahead, sir.
So Judge, you've read the paper, so I'm not going to go into too much detail other than what's said. I don't want to repeat myself too much, but just to point out a couple things. Here, there are two components that need to be shown. You need to show prejudice. Well, you need to show a delay, first of all. That's clear. I think that's clear on the facts. Murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial of the first trial, Catherine Magbanua and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have.
Yeah. Now they are beginning with the thing that I believe the attorney makes good argument. Everything the state is proposing in this trial is information they had 8 years ago, 7 years ago, 6 years ago. But meanwhile, the prosecution's tactic has been one at the time. First, the hitman, the people who actually committed the murder. Then the middle woman, Charlie Adelson's former girlfriend, who made the connections between the hitman and Charlie. Charlie was convicted last year because he paid for it. And now Donna Adelson is charged because she allegedly is the orchestrator of everything here. Now, we still have to presume her innocent. I reluctantly say this. But if the state have not charged her, even though they had the evidence 8 and 9 years ago, well, let's just listen to the arguments from the attorney.
Been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine Magbanua, Secreto Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I ask the question is because the motion makes a reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of the motion, correct?
I mean, yeah, look, she could have been charged anytime after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, and to be clear, this is not a statute of limitations. There is no statute of limitations.
There is none.
So we agree with that. But she could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear in 2024. So the only new evidence since then is her trying to get on an airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016, right? And they certainly had it in 2019. So 9 years is 9 years from, I guess, the murder, right? But if you're looking at it in any component, you're looking at what would fit under Florida law, under the 11th Circuit law, certainly a time delay, okay? So when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of their main components of their case are call patterns, and I use the word patterns lightly, because in order to show a pattern, you need a length of time to show a pattern. So when they got call records, I believe, starting in May of 2014 through July of 2014. So they got a very short period of time. Because she wasn't charged in a timely fashion, call records showing that there is no pattern, that this is exactly what would have happened earlier. These pattern calls existed back then, but they haven't existed for years.
What was the retention policy for the phone service provider?
I believe it was 3.5 to 4 years. So that would take you back to 2019, give or take. And so we're able to not fully defend that point because the records don't exist anymore. That's prejudice. The second component are some text messages. So they have text messages where they claim it shows that she is outside of Charlie Adelson's house. We have to defend that. It's their one main piece of evidence. This is a premeditated crime they're charged with. Is there one piece of evidence after the murder? There's very little piece of evidence after the murder other than that and the wires. So the way to defend that is through SunPass records. Those SunPass records don't exist anymore. Now,
What is the record retention on the Sun bill?
3.5 years is what we're told. And that's what Agent Corbett testified to at the last trial. So, Judge, it's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves. Now, the second component is a bad faith component. I think the prejudice component is clearly established here. The bad faith component, it's important to know that under bad faith, you do not need to show a sinister motive. The law in this court is clear, right? United States v. Foxman, 87 F3rd at 1223 says that bad faith in this context does not require a subjective sinister motive on the part of the prosecution. That's important. Okay, we don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip, and they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time, they didn't flip. And so they waited, and because of that, we were put in a position where these records no longer exist. Now, Judge, we do argue in the alternative in this motion. And what we argue is if the court is not willing to dismiss the case, they should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all call records, but they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists, and we don't have the ability to show it. With regards to the text message, we think it should be excluded. The SunPass records would clearly show whether Mrs. Adelson was at the house or not at the house. It would definitively show. Well, let me tell you why. Because you would see what SunPass records show back then, as they did now, is they show entry onto a turnpike.
Correct.
And so you would be able to see when she entered the turnpike.
Let me stop you there.
Yeah.
Are there not methods to travel and avoid the turnpike points? Where it might not be as direct, it might not be as easy, where if you enter the turnpike here, you have an easier point of access to drive. But ultimately, could she have reached Mr. Adelson's home and avoided the SunPass altogether?
Their record shows she did enter the turnpike. Their own witness shows that she entered the turnpike because he's got, on his many charts where he guesses, he's got her on the turnpike through a cell tower. So you don't have to guess that she entered the turnpike. You know exactly that she did enter the turnpike. Their own records show that she entered the turnpike at what's called the Dolphin Expressway. Okay? So you go take 95 and you get on the turnpike at the Dolphin Expressway. That's where Dolphin Stadium is. You would first of all see on the SunPass the entrance there. And their records show that she's on that. Their cell tower records show that. Okay? Their cell tower records show also time frames on that same turnpike. Shows on their map, on their dots. They show her on the turnpike. What it can't show is if she got off the turnpike, it may not have shown her get off the turnpike, but it would show her get back on. So in other words, if they're correct, and she had gone to Charlie Adelson's house, which she didn't, but if they're correct, at some point she would have had to exit the turnpike. Okay? It wouldn't have shown her exiting the turnpike because when you exit the turnpike, it doesn't show you exiting. But they have her at a certain point in time back on the turnpike. They would have known when she got back on the turnpike and where. And that would have showed whether she was at his house or not. Definitively, it would have shown it. We wouldn't have to guess about it. It's just how the turnpike, it's just how the Sun Pass records work. It shows when you enter, and then it shows parts at the turnpike. So they're using a witness to make guesses. They have these beautiful charts where they have her pinpoint, and then they have Charlie Adelson's house, and they show that it could take from this time to this time, extra time, but they have no idea when she got off, where she got off, why she got off. And they would know for certain, 100%, we would be able to show for certain, 100%, if we had those records, whether she was at his house or not.
Excluding for one moment a future argument about Sergeant Corbett, why are these not right topics for cross-examination?
Judge, clearly if they're allowed in, they're right topics for cross-examination, but you have to do a balancing test. This is the premier piece of evidence in this case. It is the number one piece of evidence in this case, outside your house, because it is the only piece of evidence in this case, other than the wires, that ties Mrs. Adelson to anything after the murder. It is the only piece of evidence. We have the wires speak for themselves. We have the checks that she wrote. We're not going to argue that she didn't write the checks. This is the only piece of evidence. And you're using conjecture to get it in, where if they had charged this case in a timely fashion, we would be able to show definitively she wasn't there. That's not our fault.
All right, let's go back to the U.S. Supreme Court case that is the...
Again, folks, reluctantly, I believe this attorney is making a good argument. Had they charged her when the record still existed, the defense could have taken these phone tower records, the phone records, maybe the car GPS to show, no, you're wrong. She never went there. But since those records no longer exists, they can't defend themselves properly against the state's assumption. And yeah, there are much more. There are other pieces of evidence, but this goes to the premeditation, and she's charged with first-degree murder. And which would mean life in prison in Florida. But what I believe the attorney is going for is to have first and second gone. And yeah, I'm not sure which lower. Maybe it's the conspiracy. If this lawyer is successful, I think that forces the state to go for lesser charges, which might be easier to defend against. But this is a motion to dismiss, and there are more than this. But let's keep listening. Hello, cat. Yes, I'm worried. I'm usually not a hat person. I like this hat.
Genesis of this argument with Osco. I believe Justice Marshall goes through the role of the prosecutor and their duties, and also discusses how the prosecutor has an affirmative duty not to charge someone before they have probable cause, to thoroughly investigate the case, and also not to clog the court system with cases they cannot prove. What is your response ultimately to this discussion as it relates to this case?
I think it's a very fair question. I think what you have to do is you have to then look at what has changed. So in other words, in doing that, that can't always be their answer, right? They can't just have a blanket answer. You have to be held accountable as to, okay, what has changed, right? And the reality is, when you look at this case and you see what is going to be presented, you have the exhibit list. When you look at the exhibit list for this case and you compare it to the exhibit list in 2019, it is essentially the same exhibit list. 2019, the first trial. I'm not even talking about Charlie Adelson's trial. It is essentially the same exact exhibit list. Their exhibit list contains, essentially, against Mrs. Adelson, emails that they had back then, wires that they had back then, checks that they had back then. That's essentially their case against her, okay? So the reality is, I mean, you're right. They should not charge people that they don't have probable cause for, but that can't always be their answer. They have to be held to ask, well, what has changed? We asked a similar question in the last trial, and their answer was dolce vita. Okay, but dolce vita doesn't apply to Mrs. Adelson. She wasn't there, right? Everything that they had in 2000, and by the way, they had dolce vita, they just didn't have a clear version of it. The reality is you're going to see that 95%, probably more, of this case that we're about to hear is the same exact case as it was in 2019. Almost the same witnesses, almost the same evidence. It's the same case.
Any further argument?
No, Your Honor.
Ms. Dugan or Ms. Kappelman?
Let's hear the state's response. She was good in
So
last
as
time.
the defense's motion states, the test here for is going to be whether substantial prejudice is caused, not just prejudice, to the defendant's right to a fair trial, and was it the product of bad faith, so that dismissal is required. The two pieces of evidence that they talk about in their motion are the phone records and the SunPass. So I wanted to quickly go through each. For phone records, he says, well, there are call patterns between the parties that occur on major events during the planning of this murder that the state presents. But every time we present this evidence, we also concede and present the fact that the people in this case, they all have relationships outside of any planning for this murder. Their boyfriend, girlfriend, their parent, child, they have children together. Those people in those relationships talk every day. That's normal and that's to be expected. And all these people do talk every day during the time that we have these phone records. Every time we've tried this case, the defense picks a random day. This is every trial we've had since 2019, I guess. Every defense attorney picks a random day that summer and shows that, hey, there's also calls between these folks on these other days where there's not a trip to Tallahassee or some other big event in the planning of this murder to show exactly that. They've done that every time through cross-examination, and they do that without having prior records prior to May of 2014. So there's no substantial prejudice to the defendant. And there's no bad faith here. Law enforcement subbed records beginning in May of 2014 because they were trying to get records from around the time the shooting occurred in July of 2014. So a little bit before, and then also we have records after. We have records leading up to 2016 where there was no murder being planned at that time. And obviously all of the parties in this case, as we established in the case, are still in contact, are still talking because they all have those pre-existing relationships.
Before you continue, is there a reason the records that are at issue in this motion were never pursued?
Because those are the times around the June and July trips where there was the attempt to kill and the murder of Dan Markel. We have messages between them going back before that time, but we believed, or law enforcement believed at the time that they subpoenaed the records, that was the most relevant time to the information in this case that would be relevant to this case.
Were any further subpoenas as to SunPass or phone followed up on once the state believed it did have probable cause against Mrs. Adelson?
I believe that after, so getting to the SunPass records, the SunPass records, we did, I think, try to get late last year once it came to the light that, can I address the SunPass records and I'll let you know kind of what it was? Okay. All right, going back to the phone records, though, this is not substantial prejudice, and it's not a situation, though, where the state purposefully did not indict Ms. Adelson until she could not get these phone records anymore. So there's no bad faith in this case. It's not a situation where we purposely didn't indict her so she couldn't get that. Moving on to the SunPass records. First of all, there's no substantial prejudice that these records would be exculpatory. As the court pointed out, we don't know if there was a way she could have avoided that. We don't know if the exit or entrance even had a transponder in 2014. In fact, given that the defendant texted Charlie Adelson outside your house, and there was a witness at trial, Catherine McVanois, who said that the defendant had been at the house that night right before she arrived, we believe the SunPass records could very well be inculpatory. And there's no bad faith here because we would actually like the SunPass records too. We did, as the court asked, we had Jason Newland make a call to try to see if we could get the SunPass records. I believe it was last fall in 2023, but we also learned that they don't have them anymore this far late in the game. But the bad faith portion of this is only satisfied when the government makes a judgment about how to proceed with litigation to gain advantage over the defendant, and as a result, the indictment is delayed. The reason we didn't try to get the SunPass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine McVanois offered that information in 2023, leading up to Charlie's trial and at Charlie Adelson's trial. Catherine McVanois mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before you continue,
Yes, sir.
was this new information learned either through the proffer or trial preparation that had never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which
Then how did they know? How they had all that information regardless of what Catherine said. They had that information just because it was confirmed. Yeah, I'm not too keen about the state's argument
well in
here.
2023, the trial being Charlie Adelson's trial in fall of 2023. Obviously, Donna Adelson's phone locations, right, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from, and that was this relevant to the money drop until Catherine Manvanwa said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was.
In Charlie Adelson's trial, their argument was that Charlie had the money all along. They argued to the jury and to the court that he always had cash, and now all of a sudden he didn't have the cash. It was a money drop. I don't like this at all, and I hate saying it because I want to see Donna Adelson in prison because she's a despicable person. I don't buy this.
Dan, she believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived, and that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, and we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside your house. But this wasn't a situation where we waited to indict Donna Adelson until some past records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had to have been a deliberate act to gain a technical advantage, and that's not what we have here. I also point out, Dan Rashbaum has said that he was retained in this case by Donna Adelson in 2016. Every trial that we've ever had has been, on YouTube, if anybody wants to see it. And they could have, if they believe that these SunPass records and phone records were so exonerating and obviously needed, those could have been requested prior to when they would no longer have been able to have been received.
Can the defendant, absent an active case?
Ooh, now they're blaming the attorney for knowing. These are all separate cases. Now, I do believe Donna Adelson did a major mistake in retaining Charlie, because this is more the family lawyer. He was retained back in 2016. So I do believe it was a mistake to keep this lawyer in both because he has a duty towards Charlie Adelson, because that is up on appeal. There are things he cannot disclose to Donna because he has a conflict of interest. Now she has waived this interest, and that helps the state with this argument.
Extend a subpoena
Well,
of this nature?
the defense said in the last trial that he tried to get the SunPass records and he wasn't able to before we had even thought to try to get them.
Please
I'm
continue.
not sure when he tried to do that. Another thing here is that if the court denies this motion, I think at that time it would become right, the state would ask that the defense not be able to argue in opening or closings or testify in their own questions that, hey, because the defendant wasn't indicted until 2023, that means law enforcement or the state attorney's office didn't believe they had enough evidence. What anyone in law enforcement or state attorney's office thinks in this case is not relevant.
This is interesting. This is really interesting. So even the state thinks they have a weak case if they're arguing that don't let the defense argue this.
given that, we believe that, obviously the dates that law enforcement received evidence, the dates that, suspects were tried or convicted, those things are all fair game and can be pointed out by the defense. But not the argument that this delay was because the state attorney's office or law enforcement didn't believe there was enough evidence to convict.
So to summarize in a nutshell, the state did not even understand what it had in the way of a text message until Catherine McBannel was proper.
That Catherine McBannel's information that she provided to the state really made us zero in on that and realize that money could have been exchanged at that time by Donna Adelson to Charlie Adelson. And so, obviously, we always knew that they were traveling up to Tallahassee that night, the Harvey and Donna Adelson were.
After the murder took
Yes,
place.
sir, but Catherine McBannel's information that we learned.
Again, they argued in the Charlie Adelson case that Charlie had the money all along.
After her trial, when she began to cooperate and leading up to Charlie Adelson's trial is what made us zero in on that.
Very well, thank you. Brief response, and then we're going to move on to the other motions.
Sure. Judge, I'll do the factual point first. I was retained to represent Donna Adelson in the late summer of 2016. Okay, so I think it was the end of July, beginning of August 2016, I was retained to represent Donna Adelson. The first trial happened in 2019. When that trial happened, we tried to get SunPass records. We did. We couldn't, because we weren't an active party. We didn't have any subpoena power.
Were you stonewalled by SunPass?
They told us, yeah, exactly. Okay. When we tried to get SunPass records again was when Charles Adelson was indicted in the case. Then we were able to subpoena and try to get SunPass records. We were unable to do so because they didn't exist. So let me be clear on that. Okay. All right. The first time we were able to attempt to get SunPass records, they no longer existed. Okay. Now, with regards to them, she makes a point that every counsel has picked a prior date. Let me tell you what happens. We did pick a prior date, but our universe for picking a prior date is like this big, right? And you'll recall at the last trial what happened with the prior date we picked, right? We are getting prior dates. They found court filing on that prior date. By the way, the court filing wasn't anywhere near the time of the calls, but they found a court filing on that prior date, and they made a big showing that this is another event, right? The reality is we want to find dates in 2013, in 2012, in January of 2014, in February of 2014. None of those existed because what they did is they got records only for a 4-month period of time. And any date that we picked,
As to that point, and I understand what you're getting at, but don't defense counsel in all manner of cases all the time say the subpoena was too wide, you cast too far. Meaning, the murder, what led before, what led after, there's really not a lot of argument as to the relevance. But if the state is seeking records on your client, or hypothetically any defendant, going back years in advance, are they really permitted to do that?
they don't need to go back years in advance, but they're presenting evidence in this case. Let me make 2 points to that. First of all, they got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back. Number one. Number two, they're putting emails in this case back from 2012. Why not go at least back to 2012 or at least back to 2013? They just cherry pick a 4-month period. And by the way, the records she talks about that come on later, they're related to the bump. They're not related to anything else. They're related to the bump. So yeah, they created an activity, and of course, that's going to create another pattern, right? The reality is it's unfair because they're making a pattern argument that doesn't, if it was a science experiment, it'd be a false experiment. Their sample size is too small, and we can't counter it because the records don't exist. And we don't need to show that they did it we don't need to show that they indicted her after the records existed. We're not claiming that that's what they did. They made other strategic decisions to delay her indictment. And those other strategic decisions had this consequence. And because of that, if you don't dismiss the indictment, you should not allow these records to come into evidence.
Do you have any response to the effect of the proffer as it relates to the messages? Ms. McDowell's proffer, which was taken last year.
Of course, they had the message well before then. They had the outside your house message well before then. It's not, listen, when I saw it in discovery, which was before the proffer, I knew exactly what they were going to argue. It's very clear. You didn't need her crazy argument to know what they were going to argue.
Well, let's look at this from the aspect of bad faith. Is it possible in a voluminous case file to not know what this one piece of paper actually means until a later date?
It is possible, but you have three, because there's been 3 prosecutors in this case, very fine prosecutors who have tried this case going into that case 2 times. So very unlikely. Very, very unlikely. That's what I would say. Possible? Yeah, anything's possible. But it's not that hard of a message to figure out. You have one of the key suspects in the case who you've got other records for, communicating with another key suspect in the case, who, by the way, in 2019, their theory was the same, that it was a murder for hire done by these 2 individuals. You have those, and you don't have many text messages between the 2. And you have one, and by the way, you only have like 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up outside your house, 10 minutes is the response, was not an important text message. I mean, if you believe that, I don't know, Judge. That seems a little, I'm skeptical of that.
Did they have the benefit, though, of the proffer until Ms. McDonald gave it?
They didn't have the benefit of the proffer, but you should listen to that proffer, because she doesn't talk about the outside the house message. And by the way, in that proffer, she doesn't even really talk about what they say she talks about. She did it on the stand, but she didn't do it in the proffer. That's not my memory of the proffer. She didn't say in the proffer that I don't believe that they had just left the house. That's what she said on the stand. They'd already put in the outside, they'd already marked that as an exhibit. So, Judge, again, the standard is lower than what they're saying. Right? It's a bad faith standard, but it doesn't need to show that they purposely waited until after the SunPass records didn't exist anymore. We're not alleging that. We don't think that that's what they did. We think they made other choices that then made it. Look, at the end of the day, Judge, what it also is you get to do a balancing test. And it's a fairness argument. But aside from everything else, it's a fairness argument.
It's clear that Vasco was rooted in due process.
Yeah, it's a fairness argument.
I'm going to reserve ruling as to this. Also, prior to making a ruling, I'm going to review the trial testimony of Ms. McDonald concerning the outside your house text message, as I believe it does give context to what is being argued in the motion by both parties. Right.
Miku's headphones. This is nitpicking the smallest bit of evidence in a slam dunk case. I don't think so, because the state has to show that first Mrs. Adelson was there. They have to show the pattern, that this was an unusual event. And the defense cannot defend themselves against it because the records no longer exist. So this is purely procedural, because without that, the state's case is severely weakened. Should they have combined the trials with Charlie and Donna? Yeah, in my opinion. Yeah. But they didn't, and now they have a problem. Do I believe the state has enough for a conviction? Depending on how they present it. But the fewer pieces of evidence, the less probability. Thank you for your comment. Good comment.
Let's move on to the defendant's motion to hold trial in courtroom 3B. Mr. Morris?
Yeah, she wants a smaller courtroom, less room for family and stuff.
There are a couple of practical reasons. You're going to be the best judge of what occurred during Charlie Adelson's trial and the interactions with jury and gallery. Essentially, this motion seeks a prophylactic measure against that. You're great at controlling your courtroom and being able to interact with the audience and gallery.
But you still want a different courtroom.
Yeah.
Don't butter me up. Get to the point.
Fair enough. Judge, where we sit at council table there, the prosecutor's table obstructs the view of jurors 1, 2, 8, and 9. There's no ability for Ms. Adelson to view those jurors. There's no ability for the jurors to view Ms. Adelson or defense counsel. And of course, that's an important facet. Defense counsel sits here, displays here. Examining a witness, you park at the prosecutor's table, of course. Disconcertingly, in the last case, there were circumstances where communications between counsel and the defendant are posted on the internet before the lawyer can even get back to their hotel. And so it's been interesting to read the media response. This isn't a circumstance of trying to curtail the media's ability to gain access. It's a function of trying to facilitate there are fewer opportunities for problems to arise. it's a practical consideration, and of course, all of this is in your discretion.
Well, I was going to say, in researching your motion, I did not come across a fundamental statutory or procedural right to be tried in a particular courtroom. Do you have one to argue today?
No, I do not. It's a due process argument and an argument of prophylactic measures to protect against. And then the last component, which I've tried many cases in the courtroom, multi-co-defendant cases in the courtroom. All of them are different. The acoustics in this room are rough sometimes. But from the number of inmates that we potentially have testifying in the case and the movements of people,
Yes.
it's not my challenge. It's the bailiff's challenge. There are security issues, and I know there's difficulty here. Courtroom 3B is smaller and more compact. I know that someone has mentioned that there are technological concerns of it being antiquated. Now, better time for us to ask court admin for an upgrade. We've got time to be able to put a machine in that works appropriately. There's really a functionality and a practicality argument to make sure that we best protect Ms. Adelson from things that we've seen occur previously.
Very well. What you raised about counsel table, when we do have co-defendant trials in this room, a second table is added. As the defense's preference to ultimately have what would be considered as the co-defendant's table and face the jury for the duration of the trial.
I think we're, irrespective of which courtroom, I think that we would need a second table anyways. We have one additional person sitting at counsel table with us during the trial, so there would be 4. So we'd have the traditional L, if you will, from whether it be in 3B or here. It's a little bit more difficult here because of the configuration to be able to put that many people. But to answer your question, yes, we'd like to be facing the jury, but 3B, I guess.
Very well. Response from the state as to this motion.
Yes, sir. Yesterday, a letter was sent by the Markel family stating their reasons they wanted to remain in 3G. Did the court receive that?
I was able to review it. There were also some other letters that I received, either from concerned parties that were forwarded, I believe the state and defense as well. Did everyone receive the letters of the concerned parties?
Yes, sir.
You may continue.
Aside from those letters, just from the prosecution's perspective, the primary reason for us asking that it remain in 3G is just from a practicality standpoint in presenting the case. 3G, we have the big screen overhead. We have the multiple screens in the jury box for the individual jurors. We have a screen, an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes the state has to actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and I know
You
the court
know
knows.
I hate that television.
Right, it's a pain. And so, being in 3G isn't just something that we do or we've asked for. In this case, we asked for it in all cases where we have a lot of visual evidence to be shown. In this case, we have surveillance video, cell phone records, maps, texts, emails, financial records with graphs and charts and electronic wire transcripts and other visual demonstratives that I think will be much easier for the jury to see and understand if the trial is in 3G. In the defense motion, they bring up, the inability to see the box that the judges already, or as the court's already addressed. They also bring up the lectern placement as an optimal. I routinely will move the lectern with the microphone over to the projector so that I can operate the projector, or have my laptop up here on the lectern so that I can use my laptop and have it on the big screen so that I'm still at the lectern and not, and can move it about. And I think that should solve their problem, the ability to move this lectern around. Finally, I just want to point out that, the defense is concerned about juror distraction. However, in 3B, the jury box is extremely close to the gallery. So I think that there's a risk for distraction there as well. And I think that the court in the last trial, through instructions to the jury and through making sure there was no cell phones used, was able to remedy that.
Very well. Prepared to rule on this issue today. I believe as the final jury instructions make clear, the jury will be instructed that they are to decide this matter based on the nature and quality of the evidence presented. The court is going to take all means necessary to avoid there being any distractions from persons present, sitting in the gallery, or attempting to improperly influence the jury in some manner. The examples that were cited by the defense, the court is not taking lightly. At the same time, the court does not have a way to ultimately prevent what is being complained of in the motion from happening in any courtroom. I am going to be very diligent and also very thorough in deployment of bailiffs as it results in this matter. The court also will take all suggestion from the defense as it relates to the placement of the table, so the defendant can be clearly seen by the jurors throughout the trial. As to the placement of seating on the defense side, ultimately, any observers or onlookers in the gallery are going to be placed at least 2 or 3 pews behind the defense, so that way there can be no attempts to either photograph or record the defense's interactions with each other, with Mrs. Adelson, or attempt to get any snippets of papers or other matters. Concerning the media and also any onlookers, I'm really not going to get into why people wish to come, if they have a legitimate interest or if it's just a curiosity for them. The Constitution provides that the courtroom will be open unless there is a statutory or otherwise basis for closing the courtroom or excluding persons. The courtroom is considered open. However, the conduct of those persons, the court will closely monitor. Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around.
Yeah, this judge is not playing around in his courtroom. He has complete control. I like this judge. I like his rulings. So, well, I don't always agree with it, but I do see his point. But compared to other judges we all know and heard and seen, he's a role model, in my opinion.
Defendant's motion to move the trial to courtroom 3B is denied, and this is also for practical purposes as well. Courtroom 3G is the most recently renovated courtroom in the Leon County Courthouse. It has technology options that are unavailable in the other courtrooms, and it is also best capable of accommodating the needs of this trial itself. If the state can prepare an order or defense as to the denial. Let's move on to the defendant's motion to suppress wiretap interceptions.
Yeah, I think listening to this is good because normally people join it at the trial start or the middle of the trial, or as in the Young Thug trial, when somebody screws up completely. And so it's good to have these pre-trial motions so people get a better understanding on what leads up to trial. Because at trial, there should be no surprises. The evidence should be clear. The discovery should be done. Everything should be done pre-trial. The Young Thug trial is an anomaly. It should never happen that way. So this is a good a teaching ability or what. Yeah, it's a good way to learn.
Judge, I'm definitely not going to belabor this motion. It is the same exact motion that was filed in the last trial. It was denied in the last trial. The only difference in this motion is we have a section where it shows that Ms. Adelson has standing to make this motion. So, Judge, I'm just going to rest on the papers. It's a preservation motion. We respect your judge's ruling previously, and I don't think, unless you want me to answer any questions.
I don't believe the state is contesting the standing of the defendant to raise this issue, correct?
Correct, Your Honor.
Does the state have any additional argument to make concerning those?
Judge, I do have a couple things I think I should put on the record so we're not relying on your previous ruling in this case.
Go ahead.
As you see, there should be no secrets once you get to
Well,
trial.
as to certain findings or conclusions of law as to my review of Judge Hankinson's authorization, those to a certain extent I will be relying on, but I'll allow you to continue to make your argument.
Yes, sir. I just want to put a couple things on the record regarding a standard for, it's alleged in the motion that necessity is a standard, and truly that's not the case pursuant to Phillips v. State 346 Southern 3rd 1252. Exhaustion and the objective of the criminal investigation are the standard. And in this case, we have met that standard by showing that other investigative efforts have tried and failed, or are too dangerous, or that this wiretap in this case was the most reasonable investigative technique under the circumstances. Regarding the objectives of the conspiracy in this case, the objectives of the wire in this case, it was to reveal the identity of the conspirators and their role in the conspiracy, so the structure of the conspiracy, and that's permissible under McGuire v. State 307 Federal 3rd 1192. That's a 2002 case. So here again, we're trying to identify the persons involved and gather sufficient reliable evidence to prove beyond a reasonable doubt what their roles are, what's the hierarchy of the conspiracy, is there any additional physical evidence that can be gleaned in this case, any information regarding monies or assets or other things of value. Regarding the staleness issue that's raised in the motion, I did want to point out a couple things. We note that the issue of staleness cannot be solved by a simple application of numbers of days without consideration for the overall particular circumstances presented in this case. Here, the circumstances of this investigation required efforts that involved a lot of record gathering and waiting for records and receiving records and analyzing them before we got to the point where we had reached exhaustion and we're looking to seek a wiretap. The state subpoena served on 12/14/15 requested a bunch of records between 14 and 15. Those were received in 16, including this defendant's checking account. We then subpoenaed a bunch of different Adelson accounts, that, including the one that the checks came from, and those were not received until 3/1/16. So, you know, that accounts for the timing. And there's a case that talks about, did I get it for you? Delay being appropriate in conspiracy cases, or more leeway being given in conspiracy cases because of the nature of the investigation. It's going to take more time. And I think that is, yeah, State v. McGuire, and Judge, that's at, I'm sorry, it's US v. McGuire 307 Federal 3rd 1192, and that's a 2002 case, which I already cited. Sorry to do that twice. But that case specifically talks about the government being entitled to more leeway in its investigative methods when it's pursuing a conspiracy, as it acknowledges that's a different type of case, different type of investigation. Lastly, Judge, I just want to touch on the issue of fresh evidence. You know, as mentioned in the application for the wiretap, law enforcement anticipated the use of an undercover operative in conjunction with this wire, because in doing so would
Thank you, Otto, for becoming a member. You are now a part of the Viking crew. You have access to members-only emojis here on the YouTubes. You have access to members-only content on my YouTubes, and there is a link for you to the Discord, which is all for you members. Thank you for becoming a member. Thank you so much. Let's continue.
The fresh results, the chatter on the wire, and fresh new evidence among these co-conspirators. The chatter that occurred between them to handle the blackmailer was brand new communication that could only be intercepted using this wiretap. With this new evidence, the argument of stale probable cause becomes moot, because the new evidence was being created at the time that the wire was up and the communications were being intercepted. And there's a discussion of this fresh evidence and the importance of gathering fresh evidence in US v. Maestas, MAESTAS, 2016 Westlaw 9725188. So that was all I was going to put on the record, unless Your Honor had some questions for me or wanted me to put anything else.
No additional questions. As to the application for the wiretap, did the defense have any additional exhibits that were previously not provided during the Charlie Adelson motion hearing or for this motion?
No, Your Honor.
Very well. The court will file its written order in this matter. Let's move on from here.
Judge, can we just ask that those exhibits be incorporated in the record here?
Yes.
Thank you, Your Honor.
All right, let's move on next to the defendant's motion to use a jury questionnaire.
Judge, the law says that it's discretionary. I think Judge Neff is doing one this week or this coming week, if I'm not mistaken.
Homicide?
Yes, sir. I saw some email traffic from Ms. Gaston with respect to it, but the objective is for jurors to come in, not talk about, hey, what do you think that we're here for, and what's your opinion on what we're here for, and let's discuss the case. And if we're able to have them focus on the answers of the questionnaires and then submit it, the defense feels like we're miles ahead in terms of information gained, decreasing the possibility of tainting the venire or the pool, and being able to hone in quicker on issues. Now, all of the questions, Your Honor may take exception to some of them, the state may take exception to some of them may need to be recrafted. It could be made shorter, but the overall goal is to see if we can get more information in the door before we have to start doing work with them.
All right. From the procedure that was used by both myself and Judge Wheeler, I believe also Judge Hankinson, is there a particular thing that you're pointing to that otherwise negatively affected getting a jury?
I think there were instances have been brought to my attention, and I think it became evident in Charlie Adelson's trial that the jurors had been downstairs once they got up here. They had been downstairs and that there was communication amongst them about the very thing that I was mentioning. Why are we here? What's your opinion on this?
They also did not remain.
I'm sorry.
They also did not remain.
Understood.
Well, I'll put it this way. If you can't follow instructions at the outset, there's no reason to keep going with you. If anyone that I find in that way,
You're unlikely
we
to
don't have to
follow.
worry about them being on the jury, but go ahead.
Are there additional instances of problems? I don't think my answer is yes, there are additional problems. I think it's a circumstance to be able to make it better and make it work more efficiently.
Very well. Response?
The state objects to using the questionnaire. We think, we'd like to hear and see these jurors answering the questions that the court asked last time. Sometimes it's just as important to see how someone answers the questions and their body language and what they say and how they say it, as it is to hear the words that they're saying. And so we'd like to not have one for that reason. Also, we just don't believe that it would save as much time and be as efficient as the defense thinks it may be. I think we have to litigate, well, what does it look like? And both sides are going to want something different. And then we've got 5 or 6 pieces of paper for each juror that the juror then probably ends up getting asked about anyway. So the state would object to it for those reasons.
Very well. As this motion, the court will rule on it now. The court is going to deny the motion, and again, looking at this on practical grounds, ultimately, there is going to be examination by the court on the issues of pretrial publicity and hardship to serve in a trial of this length. The ability to engage an individual denier with the entire denier that has been summoned will sufficiently accomplish the goals of a jury selection. Both parties will be able to follow up on the court's questions. Additionally, as well, as my memory serves from the Charlie Adelson jury selection, several individuals who either were going to be cause challenges or other issues were discovered, such as them seeking to gain admission to the jury, were thoroughly rooted out during the process. In that way, this will work the same for Mrs. Adelson as well. Anyone who is biased or anyone who is trying to gain access to the panel improperly, we are going to get to the bottom of it. The process has worked. I believe it will work again. All right, let's move on to the defendant's motion in limine. As to the first prong, testimony concerning pre-arrest silence, the motion indicates that the state is not opposing this. Does the state have any additional argument, or is the position changed?
No, sir.
Defendant's motion in limine is granted as to prong 1.
Again, this is how pre-trial should happen. No surprises. There should never be any surprises. And this goes again. Public scrutiny. Everything is in the open. The prosecution and the defense open towards each other. They have their fights in court. And then they follow the judge's rulings. It shouldn't be this. What happens in the Young Thug trial is an anomaly. It's a bad trial conducted by bad prosecutors. And in Judge Glanville's case, a really horrific judge. And when it comes to Judge Whitaker, at least she tells the prosecution for Jesus Christ, it's bad. Go for plea deals, yeah.
As to prong 2, wealth evidence, you may make your argument.
Okay, Judge, as you may recall, the state intends to call Mary Hall as a summary witness. I say summary witness because in the past she's been an expert witness, but I don't think she's an expert. That's for another day. But as a summary witness to talk about wealth records, if you recall, they put in records showing the combined wealth of the Adelsons. They go through a bunch of accounts and they show what their combined wealth was. Judge, we think this is clear that under U.S. v. Bradley, that evidence of a defendant's wealth may be admissible, both when relevant to issues in the case, but that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. Okay, this is clearly coming in for that purpose. Their wealth has no bearing on the issue in this case of whether Mrs. Adelson participated in a premeditated murder. There is no dispute in this case. We will stipulate it to it that checks were paid out of the Adelson Institute.
That was going to be my first question. And as to your general proposition, I would say you're correct on the law.
Yeah, those checks were paid to Catherine, I can't pronounce her last name, who they claimed was an employee of the Adelson Institute, the dental firm, while she never worked there. So there's a clear connection between everybody in the Adelson family, Catherine, who was the middle person between the Adelsons and the hitman. So there's no dispute there. So it should be, I mean, if it's already in, why argue, look how rich they are?
In the same way, the jury's not to consider that a defendant is indigent and hold that against them. It would equally apply to wealth. As it relates to the state's theory of the case, is there any relevant evidence of wealth that you're still disputing?
No. I mean, the argument in this case is that she paid for a murder, and that is not our dispute. I mean, we're disputing was for a murder, but we're not disputing that she signed the checks. We're not disputing that the checks came from the Adelson Institute. And we're not disputing that $100,000 was paid to Catherine Magbanua on the night of July 18, 2014. We're not disputing any of that. We're not disputing that they have the ability to pay the money either.
Was there other evidence as to transfers of vehicles or other property that is alleged to have been given to Ms. Magbanua?
There's evidence of a car that was given to Ms. Magbanua.
By Charlie.
That was in Harvey Adelson's name. We will not dispute that either. Again.
So again, it's just generally, these are wealthy people, not the specific matters that are being alleged part of the conspiracy or payment for the conspiracy.
We're not disputing any of that. So, and why do they need to show a wealth of millions of dollars? You know, and they spend a lot of time on it, millions upon millions of dollars. What is that relevant to? I don't think it survives 401. But if you go to 403, it certainly doesn't survive that.
I have a 90%, my estimate, about Thugger Daily. So enough for me to put him on the thumbnail, which will, if he subsequently doesn't show up, yeah, it makes me look like a fool, but I will hold him to it. This is the issue of holding a Friday panel show at 6 p.m. Most people kind of like to be with their families, and I'm trying people to not be there and join me instead. So, Young Thug's pick. Yes, I did. Yeah, you. Let's see. I can. Let's see if I can show it to you. The thumbnail. Dun dun dun. Hold on. Present. Stop screen. Present. This will be the thumbnail. So I am really clear with it's Thugger Daily. So these are the people who said yes or 90% yes. I have also sent out an invitation to Phil and to Sylvia. I'm still awaiting answers from them. So this is the thumbnail for Friday panel show. All right, let's get back to, I have somewhere I need to be at noon your time and 6 p.m. my time. So let's go on for some more. Oh,
Judge, this is a murder for hire. The state's entitled to prove that this defendant had the means to make the payments that are alleged, to make the payoffs that are alleged, to buy the cars, property, etc., gifts, etc., that are alleged to have been received by the killers. And it's relevant to show that they had the ability to make the $1 million proposed bribe that preceded the death of Mr. Markel. It's important to show the means relative to the payoff. So they had, this was a drop in the bucket, right? That's important, I think, for the jury to understand.
yeah,
Motive,
the Adelsons
means,
are
and how this-
crazy wealthy, or were at least before these
Very
trials.
well. As to this particular point, that will be granted in part and denied in part, as to evidence which specifically demonstrates that either Mrs. Adelson or one of the other co-conspirators used assets to pay Catherine McBanawan or other members of the conspiracy, the state is going to be permitted to demonstrate that evidence. As far as any general presentation, however, as to all assets of the defendant, that is where the line is going to be drawn. As to Mrs. Holt being examined on whether the defendant had adequate assets to otherwise participate in what would be called the $1 million bribe, or is alleged to be the $1 million bribe, the court will permit that. But again, just going into a general examination of all of their assets as to showing in some sort of way to create a wealth bias, the motion is granted in that aspect. If we need to get more specifically into which pieces will be used, we can do so. Are there questions as to the ruling?
For you who don't know, the Adelsons are an offshoot of the Las Vegas Adelsons, which is a billionaire family. Now, these particular Adelsons are not billionaires, but they had, at least at the time of the ending of Dan Markel and up until 2022, they had a crap ton of money. Donna Adelson had made arrangement for money to be transferred to a Vietnam bank, I believe, in the multi-million-dollar region. So yeah. Dun, dun, dun.
May I have a moment to confirm?
Go ahead.
Judge, may I make something clear too that might help? We're not going to dispute the $1 million offer. In fact, we're going to break it out. So that won't be an issue.
Yeah, I don't think they can hamstring us by stipulating to things. Like we still haven't.
You don't have to accept the stipulation. I believe this much is clear as a matter of trial practice.
Let me just confer with counsel about the financial evidence and see if there's any clarifications needed.
Go ahead.
To witness Hull about the time frame in which, say, the $1 million offer was being proposed. We would be permitted to ask the witness, what did you analyze? What did you look at? And did the defendant have the means to make that payment at that time? But we would not be permitted to say what was the bottom line in her bank account at that date.
Correct. That examination will be permitted. What would not be permitted is to say the defendant had $10 million at TD Bank on this date. I believe that's ultimately what the defense's motion goes to. Am I correct?
That's correct, Your Honor.
Yeah, that can be implied anyway. And I believe that the sum of money is much larger than 10 million, counting in all the properties they owned.
I think we understand your ruling, Judge.
This one's a little bit more complicated.
3 hearsay testimony from Jeffrey LaCosse.
Okay, this one's a little bit more complicated.
Not as complicated as you think, but you may make your argument.
All right, so Judge, in the last trial, we filed a similar motion and you ruled in our favor. You excluded the hearsay testimony as being just that, hearsay testimony, okay? And what proceeded to happen, as we all know, is the state then asked the question of this piece of evidence, of these statements to Wendy Adelson. Wendy Adelson denied that she ever said these things, and then they were able to backdoor it in through impeachment, okay?
Well, I wouldn't consider it as a backdoor as much as, would you agree with me? There are often times when it comes to evidence, may not be admitted for one purpose, does not exclude its use another way.
I remember this in the Charlie Adelson trial. They opened their own door because Wendy Adelson was a state witness. And why don't their records exist? The records are from 2014, 2015. They no longer exist because the phone companies and the cell tower and everything are only saved for, I believe, 3.5 years or something like that. So these records don't no longer exist. And this hearsay thing, I don't like when the prosecution opens their own door.
I would agree with that statement, but I would disagree that it wasn't a backdoor. But nonetheless, that was that trial. This is different because the question to Wendy Adelson in the outset in that trial was about a statement that Charlie Adelson made. So it fit an exception to the hearsay rule, which was it was a statement of a party opponent. Okay. In this case, the statement, if they ask Wendy Adelson the question in the outset, it doesn't fit such an exception. It's not a statement of a party opponent. Asking Wendy Adelson what Charlie Adelson said is still hearsay because Donna Adelson is the party opponent. And it's not a statement in furtherance of the conspiracy because none of this had to do with any conspiracy statement in furtherance of the conspiracy to commit a murder. None of these statements are in furtherance of conspiracy. So what I'm trying to say in short order is, number one, we assume you're going to rule the same way, that it was hearsay, and prevent it from coming in through Jeff Lacoste. And what we're also arguing is that it should come in through Wendy Adelson because that is also hearsay. It's hearsay because it doesn't fit an exception. That it would have in Charlie Adelson's trial. It doesn't fit any exception in this trial. And so we're asking that it not come in at all. Now, when you look at the statements, they're all a little bit different. Buying her a television was cheaper than a hitman. That Charlie Adelson actually looked into possibly hiring a hitman. And then that Charlie Adelson described a dinner as a celebration. That's even after the murder. So that's even, and then Charlie Adelson kept large amounts of cash in his home, right? These are all statements that are hearsay, right? They're hearsay if asked of Jeff Lacoste, and they're hearsay if asked of Wendy Adelson. And as a result, they shouldn't be allowed to be asked or admitted.
Response from the state?
I disagree, Your Honor. I think these are statements against interest. These are
One
statements.
moment. I need to remove some people from the Zoom.
Yes, sir.
Go ahead.
And are in furtherance of the conspiracy, Your Honor. If Charlie is telling the main beneficiary of this murder that he's looked into hiring a hitman, that's in furtherance of the conspiracy. And how much it's going to cost, too, was part of the statement. That Charlie Adelson had, in fact, in the summer of 2013, begun looking into hiring a hitman to kill Dan Markel, and the cost was either going to be $15,000 or $50,000. One of the two, she said, as you will recall. How can that not be in furtherance of the conspiracy, right? If Wendy denies it, then it's textbook impeachment to call the person that she said it to indicate that she said it.
And that is your argument as to all four of the statements that are being highlighted.
Yes, Your Honor.
Well, I'll reserve ruling on this topic for now. I want to do some additional research as to statements in furtherance of the conspiracy. Let's move on to number 4. Testimony from Wendy Adelson.
And Judge, with regards to number 4, the state's position may or may not have changed on some of these. I just want to let you know that at the outset. They let me know recently that their positions were possibly changing. So.
In Charlie Adelson's trial, Wendy Adelson had immunity, that her testimony could not be used against her in future proceedings. So I assume she will have the same immunity in this trial. So yeah, which kind of is where Woody was.
So here we're trying to prevent certain statements, certain questions from being asked to Wendy Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial for first-degree murder. The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes had anything to do with Donna Adelson.
Yeah. When Wendy Adelson took her and Dan's kids away, directly after the murder, she changed the kids' last names from Markel to Adelson. The kids are still in Wendy's care. The Adelsons have effectively denied the Markels, the grandparents, Dan Markel's mom and dad, effectively hindered them from meeting their grandkids. And I have 2-hour words for people who do this. And this, one of the main reasons why I would love to see all the Adelsons in prison and the boys reunited with the Markels, so they can get to be with good people. There is not one good person. Well, the third, there is Sean Adelson, Wendy Adelson, and then there's another brother who effectively told the rest of the family to go screw yourselves. I'm going to live by my own because there's something wrong with you. That one. But the rest of the Adelson clan in Florida, go fuck yourself. Oh, damn. Fork, YouTube, fork. Like knife and fork. Nothing else. It's the accent.
We don't know how that could have anything to do, again, with this case. The third is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice a jury. And so under a standard of 403, they should not be allowed.
Good. Well, also one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes and the validity of. Is everyone clear on those?
Yes, Your Honor.
Go ahead, Ms. Couple.
I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendy Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to the other two items, I think those go to the state's theory that this crime was done in order for Wendy to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right. As to that point, Ms. Kappelman, I understand the relocation and the divorce proceedings as it plays into the state's theory. But ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain parental decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant to the state's theory in the murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father, right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further arguments to this issue?
No, Your Honor.
Just one briefly.
Go ahead.
Wendy Adelson is not trial. So, I mean, this may be a different topic if this were the trial of Wendy Adelson, but this is the trial of Donna Adelson. And what they're trying to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendy Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Your Honor, for any of these things.
Very well. As to sub-prongs 3 and 4 of number 4 of the defendant's motion in lenity, I will grant that. As to prongs 1 and 2, I will give additional consideration to the argument that's been made. I will reserve ruling as to those sub-prongs from now.
Thank you, Your Honor.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay, and it's certainly not in furtherance of a conspiracy. This is after his conviction. So we're only talking about, let me be clear, we're only talking about jailhouse recordings after Charlie Adelson is convicted. So there are recordings in this case that I believe the state intends to use. I don't know, where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. There's an exception to the hearsay. It's not hearsay, but Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy. And some of the statements are inflaming.
Are any of these in any way tied to this issue of travel as consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think there are statements where Charlie is talking about his trial, and Charlie is talking about why he believes he was convicted, and Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using, but Charlie's statements are not admissible.
Right, state response.
These are statements against interest that are made by Donna Adelson or are adopted by Donna Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter of what you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think Your Honor will know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where
This was
Charlie
on the loan
actually,
application.
yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show, like, this is what's happening. It's a call where he's dropping off. She's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
That would probably be best before I rule on this.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction as it relates at least to law enforcement and a defendant's interview. Is your argument essentially this goes to the context of the call?
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well. I'll need to review these calls before I can actually make a ruling on, because as the defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problems and we have relevance problems. Ultimately, I assume anything the state would be seeking to admit is going to meet a relevance threshold from there, whether playing the entire context of it would otherwise get over the hearsay issue. That I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context.
I'm going to play in 1.5, so we maybe be able to go through the entire hearing before I have to leave.
Recording. I will read the sample instruction to the parties. You also may propose any suggestions if it is admitted. But ultimately, it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You would not consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses. That ultimately, if any will be admitted at all, that will be subject to that instruction to the jury. So it is clear, Mr. Rauschbaum. So it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. All right. Last problem, autopsy photos.
So Judge, the Florida Supreme Court has held that autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay? In this case, there is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I may be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 X-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not so certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that, again, I think it's a balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
No, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
we haven't done that in the past, but we don't intend on attacking his credibility when it comes to how the murder was done.
So you may respond.
Judge, this is a material issue that state's required to prove that the victim is in fact dead. We don't have to accept a stipulation. The photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were x-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the stippling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Well, as to this point, I will find that the value of autopsy photos are probative and the prejudicial effect does not outweigh them. The motion is denied as to this particular point. Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
This is one of the most interesting parts. Donna and Harvey Adelson trying to flee to Vietnam, who does not have extradition to United States, and how they tried to transfer money and all of that, which forced the cops to catch them at the airport. I'm not a big fan of the conscience of guilt theory, but this, I think, is quite clear that she saw the writing on the wall and tried to escape.
So Judge, I think our motion to some degree speaks for itself. In this case, the state went to tremendous means to try to wait to arrest Mrs. Adelson until she tried to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in Florida. We were unable to find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again.
No.
I think we beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know, I'm far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity? In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases. There's a couple cases that I cited. And here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is you're going to see that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers about it. Okay, you're going to see that to make sure that she wasn't committing a crime. You're going to see that she used her own passport. You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to Mexico or fly to San Antonio, walk across the border, go. You're going to see that everything was pretty open and notorious, things that would contradict flight. And so,
Let me stop you there.
yes,
Does flight have to be surreptitious?
it doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances, when you're determining whether it goes to consciousness of guilt, flight is a component, right? If for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight. When you look at the totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say 7, but after she's a suspect, you see that she's traveled many, many times and always come back, right? So, and by the way, you hear phone calls. They're phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going and what she's doing, right? And so, look, consciousness of guilt is a very, look, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions. But I'm here.
Well, is there any other evidence that puts context on this travel?
Is there any other evidence that puts context on this travel? I'm not sure I'm understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things otherwise go to? This is not just the purchase of a flight.
Sure. There are pieces of evidence that I believe the state intends to try to admit that would show both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that. One moment. Yeah, I will. There is evidence of that for sure. But again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and what's the actor's name?
Harrison Ford.
Yeah, Harrison Ford, running around in Southeast Asia for the rest of their lives. But we think that when you do your balancing test, prejudice outweighs. We'd also say this, and this, my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. That Vietnam villa is an investment done, as they know, they've spoken as their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it. That villa.
That's under the rules of Vietnam.
No, it's like a timeshare. So even when you own it, you can only live in it for 6 days. And so when Charlie Adelson is arrested, Donna Adelson and Harvey Adelson continue to make payments for that villa because that's the agreement they have with Scott Radius. And if not, they lost the prior payments. It leads to, this consciousness of guilt argument leads to a lot of nonsense, to be honest with you. And we think that when you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it is allowed in, we'll probably ask for some sort of limiting instruction. But Judge, we think that it does fit the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails. So,
Judge, there are just as many factors that suggest that this was, or flight was, a matter that was demonstrating consciousness of guilt as the ones that they plan to argue she was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. The state feels that's relevant. If it's anything that the defense wants to argue and the facts that they pointed out are they're fair game for cross-examination, they're free to elicit those, and we can have a dispute. Let the jury decide what the evidence shows and what the weight is rather than the admissibility. But how is it a 403 problem if she's just going on a vacation and that's what they're going to show? What's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
As to this motion, I am prepared to rule. I review the cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. the motion is going to be denied. I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury, is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt. Really, it's not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that the defense would seek, you may submit that concerning this issue.
Yeah,
Right.
that was a
I believe
weak
that covers the
motion.
defense motions for today. Mr. Rashbaum, if you can submit orders, at least for the matters that have been ruled upon concerning these matters. Let's move to the state's motion in limine. As to prong one,
Okay, now the state is trying to eliminate evidence the defense wants in.
Ms. Kappelman,
Yes, Your Honor, as we have done previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts as irrelevant and bad character evidence. Did you want me to address prong one?
just prong one for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor, I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong one?
Well, I mean, I think we're gonna have to bring up the Latin Kings. I mean, they inserted it, we weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with the gang, did it not? It's just the name Latin Kings wasn't used?
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings is a relevant fact. That was actually inserted by the state in their bump operation, right? The whole point of the bump is someone's approaching Mrs. Adelson, who is supposedly also a member of the gang, and is speaking on behalf of Mr. Rivera, who wants to get paid, right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, what, how many rapes he's done,
So the name is the identifier, that is what you're seeking to make use of.
Of course.
Ms. Kappelman, response as to the use of the name of the group.
I do not agree that the name is in the evidence that the state intends to produce. If that's Your Honor's ruling, which we would request, then criminal street gang could be substituted for Latin.
Judge, we would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Miss Adelson hears that the guy,
As one gang has greater credibility than the other?
it certainly does in Miami, right? So when Miss Adelson hears that the Latin Kings are behind this, I mean, that's what she hears at some point. That's what the evidence is going to be. It affects how she does certain things, right? And so we think that is relevant and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also, once again, permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve ruling as to that. Specifically, again, in what context beyond hearing she knew he was a gang member are you planning to use this or present this to the jury, Mr. Rashbaum?
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this was a particular chapter that he was in charge of. Is that what you're getting at?
Correct.
Ms. Kappelman?
We just think it's prejudicial, more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin King. She knew there were gang members that were threatening to kill us, what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin King.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin Kings, I'm going to reserve on that issue for now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin Kings in it, we will approach.
Correct.
Thank you.
States prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kappelman?
If you go back and check my coverage of the Young Thug pre-trial things, how the prosecution actively tries to keep things from the defense and how they act here. When you have a strong case, when you believe you have a strong case, you have nothing to hide. These are simply procedural. There should be no secrets once you get to trial. As you can see here, the prosecution does not want secrets. They have revealed everything. Now it's up to the judge to decide, is this correct according to law?
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred. So I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
Response?
We don't plan on doing this unless something crazy happens in court. Then we'll approach the honor and we'll discuss it then. But we don't plan on practically talking about that.
Very well. Prong 3 is granted. Counsel for the defense is directed to alert the court should you believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor. We've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kaplan, you may make your argument.
Yeah. Now, the rest here is purely procedural, and I have to be somewhere in 7 minutes. And so, yeah, I will cover the Adelson trial as much as I can, but my main focus, as always, is the Young Thug trial. This trial is scheduled to start in October, so not so many weeks. So, but I wanted to show you this because the same happened prior to the last trial. No secrets, none whatsoever between the prosecution and the defense. It's clean trial where the evidence is being weighed by the jury. And just to make sure you all see the difference between a proper trial and the Young Thug trial. Now, I do believe that Donna Adelson deserves to be in prison, only because she's such a despicable person that she deserves some kind of punishment. Maybe the correct punishment is see Charlie in prison. Maybe Wendy will go to prison. She loses custody of the sons. Maybe that will be punishment enough. Hopefully, in time, the boys will be reunited with Dan Markel's parents, that they can regain custody. Because the Adelsons are not good people. Okay, I gotta run, folks. But thank you all for being here. Thank you for allowing me to try to present this to you. Mr. Jingles finally made an appearance, and just in nick of time, but thank you all for being here. I will see you all later today in the panel show, the Young Thug Friday panel show. All right. See ya. Oh, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Bye.